Hello and welcome to another exciting edition of Business Law Today. And in this particular episode, we're going to talk about e-contracts and the exciting world of online digital contracts. And the first thing that we look at is a e-contract. Now, an e-contract is just a regular old contract. And so all of the normal common law principles for contract law still apply in the e-contract context. And so understanding that whether it's the ACLAF principles of offer and acceptance and capacity and consideration and legality and form and all of those kinds of things still apply. And so we have to have the normal contract principles satisfied. But then there are some extra issues that arise when we talk about online interactions. So the first thing we look at is the online offer. Of course, we have to have offer and acceptance. So where does the offer take place? Now, the seller's website controls the transaction, and in some ways, online interactions are actually cleaner than on offline or real-world transactions because you don't have usually any face-to-face conversation, and so it really kind of eliminates a lot of potential disputes because everything is done online. So what exactly is the offer? Well, the seller's website should include the hyperlink to the page with the full contract. So when you click Buy Now, there's a little link underneath there that says, click here to see the full contract terms. That is part of the contract. And even though you never click on that, I'm sure you don't, even though you never do, you're still bound to those particular provisions. That's called a click-on agreement, and it's part of the requirement, part of the contract itself. So what kinds of things would we expect to see in an agreement like that? Well, let's look at an example. Here's my favorite website for buying cool junk online, and that's Woot. But my real favorite part of Woot is the shirt section. And so they have the top 20 shirts of all time. There's some real good ones in here. Let's see, where's the one I really like? Oh, this one's really cool. You've got Indiana Jones discovering Han Solo frozen in carbonite. This one's kind of funny. Outside where real stuff happens, kind of a good plug for our online contract. So where is the agreement? Where are the terms that we would look for in finding? Well, anytime you're looking for that stuff, look all the way down to the bottom. And where is it? Well, let's look back on the main page and see if we can find it there, shall we? I mean, where else could you find a website where you could buy a bidet and shoes with toes on the same website? Come on, that's awesome. Okay, so let's see here. Terms and conditions, that's what we're looking for. And as you can expect with Woot, anything like that, you expect it to be really funny, and it's not. So there are terms and conditions. What kinds of things do you find? Well, in an agreement like this, you're going to expect to see a return policy. You're going to expect to see copyright and trademark type things, how communications are going to be handled. A license and access is usually part of it, and how they're going to handle reviews, comments, and things like that. Returns and refunds are always included. Pricing information, if there's any software, terms of use are applied usually in a different place, and you can see that here. And then we get to the meat of it, the disclaimer of warranties and limitation of liabilities. And so here you have, they really want you to see that, so it's in all caps, and that really makes it stand out. And so you're really going to read that legalese. And they're disclaiming all kinds of warranties, including the implied warranty of merchantability and fitness for a particular purpose, which you don't even know what that means right now. We're going to get to that 4 chapters from now, and you're going to see that in order to disclaim those warranties, it must be in writing and it must be conspicuous, and that's why it's in all caps. Another thing you're going to see in an agreement like this would be a dispute resolution provision, and you notice here that they say everything will be done by binding arbitration, and you now know what that is because you've had business law. There is no judge, there is no jury, there is no court. The arbitrator awards damages. You're always going to find an applicable law provision, and so because of that, you're going to always have because it's an online transaction, you're always going to have people in different states and different places. And so this one says state of Washington is where the law, which is kind of interesting because Woot as a company is based in Texas. They're incorporated in Delaware, and yet they're choosing the state of Washington. And usually the reason for that is the state of Washington has very good arbitration laws for businesses, and so that's why you have that. And then they have additional terms and conditions. So kind of interesting just to see how a website like this would operate. The other biggie that I'll show you is Amazon.com, right? So I was looking at really cool masks for my son to play paintball and airsoft guns, right? So where am I going to go on Amazon to find the terms and conditions? Well, we're going to go all the way down to the bottom, not in this row, not in this row, not even in this row, all the way down here to conditions of use. And on that we find a situation where we have all kinds of the same exact things. So we have the copyright, the trademark, the patent, licensing access for the account, reviews and comments, copyright complaints, risk of loss, returns, those are always there. And notice again with the all caps, disclaimer of warranties and limitation of liability. Notice again with disputes, Federal Arbitration Act applies. Applicable law, Federal Arbitration Act, and wouldn't you know, State of Washington again. Of course, this company is actually based in Seattle, Washington, so it makes a little bit more sense that they would do that. And you see the rest of what is only described as an EPIC terms of use provision. So Amazon's got it nailed down pretty good. So what kinds of things do we see? We see a return policy, the disclaimer of liability for various uses and goods, a privacy policy, limitation on remedies, and those kinds of things. So online offers often have the form selection clause, choice of law clause. We've noticed those, and that's how they are viewed. Now, are they enforceable? Yes. Click-on agreements are considered to be enforceable. And so whether it's a website that you're viewing and buying something on or a software that you are installing, when you click I agree, whether you read it or not, it is enforceable. The law does not require the parties to read all the terms. So surprise, surprise, you can't have a defense to say, well, I didn't actually read it or agree. Yes, you did. When you clicked I agree, you took that risk. So another type of agreement, you got the click-on agreement. That's when you agree when you install software or use a website. The other kind you get is called a shrink wrap agreement. And this is a handy little thing. Software companies, back in the olden days, software companies would send you the actual software rather than just downloading. So I happen to have an example of that here. This is a Snap survey software. And we used to use this for course evaluations. I happen to have a box in my desk, and so I thought, hey, I wonder if this is a shrink wrap agreement. So sure enough, when this box came to us, it was, lo and behold, shrink wrap. There was no way to view inside the box. You could not get into it. The only way to get into it was to take off the shrink wrap. There was a sticker on the outside of the shrink wrap that said, accessing this software by removing the shrink wrap indicates your acceptance to additional terms provided inside the box. And so sure enough, if you look inside the box, you have even more boxes. And so here we have the sleeve. And inside the sleeve, the DVD protective case, we have a book. And inside the book, we have license agreement. And it starts on page 6, and it goes for the rest of the book. And it's kind of interesting here because I've highlighted this part right here. And what that says is this license agreement is accepted as soon as we accept your order of this software. This agreement takes effect when Snap Surveys accepts your order, which occurs when it sends you an email or it supplies you the software. So I'm supposedly agreeing to something that I could not possibly have read because it was behind shrink wrap. that I could not possibly have even known was present because it was supposedly accepted when I placed my order, and then you mailed it to me in a shrink-wrapped container. Well, that's kind of an interesting way to look at things. The first case that really took this issue on was actually a Gateway case. And there was an old computer company called Gateway, and they had the big cow boxes. And let me tell you something, when those cow boxes arrived, that was an exciting day. And they had additional terms inside that you didn't know you were agreeing to. And so here's what the courts have basically said. Sometimes these are enforceable and sometimes they are unenforceable. They are unenforceable when they expand or reduce, when they expand the contract beyond what would reasonably be anticipated, or when they contradict terms that the parties had already agreed on. And so if there are additional limitations of liability, if they try to change the return or warranty periods or things like that, then the courts will not enforce those because obviously the party couldn't have agreed to something that he didn't know and he had expressly said otherwise. And so shrink wrap agreements are kind of going out of style, but there have been cases where they have been enforced. That is different than what they call a browse wrap agreement. Some enterprising websites have taken upon themselves to put all kinds of onerous terms of use in a very buried legalese type of a page. And supposedly, just by using their website, you are agreeing to these terms. And then they try to limit you or make claims against you when they feel like you violated those terms. For the most part, it's kind of like a click-on agreement because you really didn't read it, right? But the difference is there isn't any affirmative acceptance. It's just like, well, you used the website, and so therefore you have agreed to all of these terms and conditions. Well, the one case we have on this that really kind of analyzed it pretty well said unless it was very conspicuous, and in that case they wanted to see it up in the upper left-hand part of the page that everyone would see immediately and wouldn't be kind of scrolling down in the bottom like we had to do with Amazon and Woot. And so they said if you had it right at the top, or if you had a pop-up that everybody had to agree to and affirmatively click I agree, then we will enforce it. But if not, we're not going to enforce browse wrap terms. And so, for example, I'll give you an example. One website said that if you leave negative comments on a third-party website about their service, that violates their terms of use. Well, I mean, come on, you can't do that. Another website tried to go after Google and said, well, our terms of use said that in a browse wrap agreement said that robots, your spiders and robots cannot crawl our website and index it for search engineering, and that if you did, you owed us $500 every time. And so then they were keeping track of every time Google's bots went through their website and sending a bill to Google for $500, claiming, contract, you agreed to this when you accessed our site. That's just not going to hold up in court. So those are browse wrap agreements. In the second half of this unit on eContracts, we're going to look at two national laws that govern this particular area. The first is a federal law, and the second is a uniform law that's been adopted by all of the states. So the first one we're going to look at is called the eSign Act, and this was passed in 2000, somewhat in response to the growing industry and the changing rules, the changing technologies. And so the eSign Act is very simple, and it's actually a very good law, and it simply says that just because a signature is in an electronic form does not make it invalid. In fact, if I could state that more positively, it says electronic signatures are just as valid as physical signatures. And so as long as the contracting parties have agreed to using e-signatures, then they are just as enforceable as any other signature. So that's a very good law, gives a lot of application, and so it's been a good development for contract law and businesses in this area. Now, it doesn't really define what an e-signature is, and so that's, in some ways you could say, well, that's kind of a weakness of the law. But what it basically has boiled down to is that any electronic indication of identity can be considered as a signature. So in one case, even someone's email address that was attached to an email that they sent, even though they didn't sign it themselves at the bottom. They didn't try to recreate their signature with the mouse. If you ever tried to do that, that's kind of hard. And they didn't do any of that. But they had sent an email and it had their name and the email address, and a court said that's good enough. That's an indication of their identity attached to this record. So it doesn't apply to all documents. It doesn't apply to court documents. Courts have their own system for electronic signatures. It doesn't apply to divorce decrees, prenuptial agreements, wills, power of attorney. Things like that have to be physically signed. And so you can't have an e-signature on a will. That would be one exception to that particular rule. So the purpose was to give an across-the-board acceptance to electronic signatures. Now, that was good, but it didn't go quite far enough. And so what has come along since then is called the Uniform Electronic Transactions Act. And the UETA has a little bit of overlap with e-sign, and so we're going to see how that works. But it goes much, much further. And the UETA was designed to remove barriers to forming electronic contracts and engaging in commerce, engaging in business online. Unlike the e-sign Act, which doesn't even define what an e-signature is, the UETA has a definition of e-signature, and it's very broad. Notice this here on the slide. An e-signature is an electronic sound, symbol, or process associated with a record and adopted by a person with intent to sign the record. Okay, so a sound can be a signature, a symbol, or even a process. And so we can have the process. It's talking about, for example, a click. If you click I agree, that is a process. That is an action that indicates your acceptance and your identity. If you've ever seen how e-signatures are handled on PDF documents, we use PDFs, e-signatures on all of our contracts with if we have outside adjunct instructors that teach for us in an online class, we send them a PDF and they just simply say sign here, they click, and it puts their name and the date and then this long string of symbols and characters. And that is meant to be an indication of their identity and their intention of signing the record. You say, well, I've also seen PDFs where people have taken a graphical picture of their signature and used that. Does that count? And let me see if I can even show you an example of that. If my thing will launch here. You say, do you have to do it that way? No, you don't have to do it that way. In fact, if I just show you here, insert, and I even have it in my quick parts, so I can just, boom, there's my signature, okay? Now, is that an e-signature according to the definition? Well, sure. Does it have to be that? No. It could simply be me typing my name. Now I have e-signed this document. And so an e-signature, it would include that kind of thing, but it doesn't necessarily have to be that kind of graphical representation of a traditional signature. Now, notice the word that's underlined here at the bottom, record. What is a record under the UETA? I'm glad you asked. A record is any information that is inscribed on a tangible medium or stored in electronic or other medium that is retrievable in visual form. And that's really the key, retrievable. It has to be reproducible. It has to be the kind of thing that we can, with certainty, know what it was when that person signed it. So it's kind of the difference between a PDF and a Word document. What's the difference between a Word document and a PDF? Well, a Word document changes all the time. A PDF is kind of like a snapshot. That's what it looked like. And if we can't reliably know what the document said when it was signed, then it's not going to serve as the basis of a very good contract. And so in order to be a record, a Word document would probably not count unless it had serious levels of reliability about the changes that could or could not have been made after it was signed. So there are ways to secure a Word document. I don't want to lead you astray. There are possibilities, but in general, a PDF is a much better way to go when it comes to contracts and documents. So what does the UETA apply to? Well, it does not create any new rules for online contracts. Instead, it says, okay, all the real world rules, the physical world rules apply also in electronic contracts. And notice it only applies to e-records and e-signatures that relate to a transaction. And so it has to be a transaction. It's the Uniform Electronic Transactions Act. It does not apply to wills or power of attorney or legal documents that are not part of a deal. So we're talking about interactions between businesses. Doesn't apply to wills or trusts, and does not apply unless both parties have agreed to conduct an electronic transaction. You can still opt out if you prefer not to do that. So I mentioned in the beginning of this unit that there's a little overlap between eSign and UETA. What do we do in that case? Well, the eSign came actually after UETA was already making the rounds, and it said that if a state adopts the UETA and conforms to the minimum eSign procedures, then the UETA will preempt the eSign Act. That means normally a state law and you have a federal law, normally what happens? Federal law wins, right? In this case, the federal law explicitly says if you adopt the UETA in your state as state law and your version of the UETA has these minimal criteria that are established, these procedures that are established in the eSign Act, then your UETA in your state will preempt the federal eSign Act. And that just makes sense. Basically, it's just saying that you've already got it covered. We don't need the federal law. All right, that's our special mini unit on eContracts. I hope this has been helpful, and I look forward to seeing you again next time we get together. Bye-bye.